I want to share with you how I can get better access on the various resources online. Now, there is one thing which I'm doing at the moment. Now, in case you've got your handphone with you, that is the way that I'm doing at the moment. It takes a bit of tuning in for you yourself. I don't know whether it applies the same way with your iPhone or Samsung or whatever. But whatever it operates, there should be a way that you'll be able to get access to the online law, for instance. I'll show you how. Now, turn on your iPhone. Turn on your iPhone and try to do it with me. Now, on the iPhone, this is how you type in order to go to an online domain. Now, this is how I do it. The best way. Now, try to key in the keywords HK space judiciary. Let's do it now. Let's do it together. HK, a blank space, and then judiciary. JUDICIARY. You got it? Got it? You got it? Oh, yep. Now, once you get in there, then press go. Then you should be able to find, among the others, something called Hong Kong Judiciary Home. Find it? No. I want you to get in there. This should be where you are at the moment. Get it? Everybody try it. Don't wait until tomorrow. All right. Once you get in there, so now, what I intend to do is to take you to the HKLII. So here, the 3 horizontal bar, key in there. Then you should be able to find, I think probably is judgments and legal reference down below. Get it? Judgment and legal reference here. It's about 1, 2, 3, 4, 5. 5th line down. Got it there? All right. Key in. Then go to related links. Related links, which again is about 1, 2, 3, 4, 5th line down. Right. Key in. Now you should see something in pink color. It's the 3rd one that I want you to go to now. This is the Hong Kong Legal Information Institute. Get it? You find it? All right. Then, again, find the horizontal bars on the top left-hand corner. And you should be around here. You see lists of databases, and then you see cases. Next to cases, there is a minus sign. Key in there. And this is what you should be in now. You should see cases, legislation, other. So the second horizontal bar should be legislation now. Get it? Go to legislation. Go to legislation. Then you see ordinances and regulations. Now, it is from here onward that you should guide yourself as in future which particular law or rules that you want to go to. So after this first attempt, you may repeat yourself, and what I intend to do is to go to that particular directory where you find the law and then try to place it on your iPhone interface so that you can get it right at your fingertip. This is how I did it. So let's try ordinance. Then you should be around here, ordinance. There are two kinds of choices. One is by alphabetical order. The other is following the numerical order. All right, so I want to go to Wills Ordinance. So you can try W, or if in numbers, 30. So let's go to W. Now with this, you'll be seeing all the statutes started with W. Then go to find Wills Ordinance, Cap 30. Find it there? Then click on it to open it. Now, then you'll be seeing all these sections of the Wills Ordinance. Find it there? Now, from now on, it will be the most difficult part for you to maneuver your iPhone. What I have done is, I tried this. Down below, there is something like a book there. See that? Here is something like a book. This sign is around here in the middle. Okay? It's around here. Now, click on it. You'll be seeing something like this. This is not what I want. Done. Go back. Try it again. Oops. Now, this is the original Wills Ordinance that we have just opened up. What I want to do is to maneuver, deal with your iPhone key in order to put this in your iPhone surface. Let's do it again. No. I don't know how to do it now, but you have to. I did it before. You do it. Then I think you need a bit of luck. I don't know how to do it now, but no. What I want to do is what I did it before, which is yeah. This one? This one? Oh, okay. Oh yeah, it's something like here. Is it add favorite or what? Add to home?
Yeah.
Okay, let's try now. No, not this one. And bookmark.
Yes, I will bookmark and can select under that menu bar order.
Really? No? Let's do it again, huh? Here, select, or add to reading list. Let's see, huh? No, not reading this. Probably somewhere else. Now I want to add here. Now this is what I have done. My favorite? All right, let's do it again. This is a home.
Yeah.
Oh, do it again, huh? This is favorite home. Okay, I'll go back to where I was. No. So, how should I do it? Here.
If you want to be your favorite, then that is
Favorite.
If you want to be the home screen.
Oh.
That will be the home screen.
Home screen? Where is the home screen?
Actually, home. Then will become, if it's done, then will become home screen.
Huh?
So it depends on how you continue.
Yeah, this is done. But I want to go further. Okay, let's one more time. We are about there now. Now, assuming you are successful, then in the future you should be something like here. Now, I must be very stupid. So every time I turn on here, then see the number one, this is number 3. This is what I have done. This is a Will's ordinance. This is a Will's ordinance. Now, I want all of you to try. If you don't know, don't ask me, ask the lady student. She succeeded. Then, every time when this is in your fingertip, then every time you open it, you should have access to it. And let's say I want to go to section 5. Then immediately, this is section 5. And the good thing is, when you're traveling like on MPR, then you can turn this on, switch to the Chinese edition. This is what I've done. I click on this. So, already, I have the section 5, subsection 2 at my fingertips. Now, for myself, I find that this is the easiest way, the most convenient way, because when you are in the classroom or in your office, you should take full advantage of the laptop. That is much bigger. But when you are traveling, then this is the best way. Turn this on, and I find it very interesting. Interesting in a way, I try to turn this learning process as something as easy as possible. Particularly for some of you don't have connected experience with this. One of the easiest way for me to do is, then what I would do is I just highlight them. And then I use the listening function. Speak. Alright, now I have just illustrated to you in principle what I intend to create. Something you can have the substitute of Mr. Wong anytime at your fingertip. Yeah, that's right. You can listen to me or my substitute. This is the best, because then you can pick up what you need to study at the most convenient way. Listen to the English, listen to the Chinese, and sometimes when it comes to near the examination season, use the Word format, type it out, have it installed in the iPhone, then you can listen to all the notes. That, I think, is the best way. You can listen to me on my notes while you're sleeping, eating, or fighting. So that will be the most convenient way. And sometimes students would like to do revision on past papers. I want to know how the past questions are set in order to assist me. All this is you turn the PDF, switch it to Word format, copy them into a Word file, then put it online into your iPhone. So this is the best way. One way, this is the best way, but then you have to do the magic like the lady student just teach me, how to put it at the surface of their iPhone or as your favorite or reading list. That I don't know how to do it the best way, like she does. But anyway, this is the way that I want you to reduce everything that I teach in the 10 lectures. Sometimes I do quite a bit of talking, which may not be directly relevant, because I share with you my experience only. But when it comes to examination, what you need is a passing mark, not my experience. You can have my experience later on. But then with the question, with the keynotes, then this is the best way. You just spend an afternoon doing things like this, and then repeatedly while you're on the MTL, then there is no way that you can fail. There is no excuse that you don't understand English, then you can turn something into Chinese. And the best way is, even if you're so stupid, if you think you are, which I don't think you are, well, get the notes and try to reduce them into Cantonese in whatever form that you like. Then again, put it in your iPhone. You can listen to a summarized version or edited version. Then all these 10 lectures can each be reduced to no more than 15 minutes. Then this is the best way for you to get through this module and move on to the others. Okay? So this is what I want to tell you before I forget. It's interesting. All right, this is so far by way of introduction. Let's get on to what we have left behind. All right. Now, last time we were still on lecture 2 talking about the test stake situation. We'll continue with that. We spent quite some time on section 5 of section 1, which is on the formal validity of the will. And then we also mentioned to the class about this peculiar provision of in Hong Kong by way of section 5 of section 2, which is informal will. The only feature that we need is a document. That means something by way of writing or something similar to writing, like in a typed version, in a computer printout, so on and so forth. But then something for us to remember is it has to be something in writing. Then after we have a higher standard of proof, of criminal standard, of no reasonable doubt, then we can move on to see if the more important element on the substantial validity is there or is not there in order to show that a will is valid or not. Now, while we are still on this PowerPoint, let's look at the first line. The first line. The first line is subject to section 6 and 23D, no will shall be valid. So this line is on section 5, subsection 1, which means the formal validity of the will, which is provided in section 5, subsection 1, there are potentially 2 exceptions, apart from section 5, subsection 2 down below. So, in other words, one exception is section 5, subsection 2. We have discussed a lot. The other 2 possible exceptions is section 6 and section 23D. The area which I like to draw your attention to in this line is this. This line is partly correct and partly wrong. Wrong in a sense, okay, another exception accepted is section 6, which is on privileged will. We'll briefly mention in a while. But section 23D is not a real exception. In other words, although expressly you see this in the wills ordinance here, but in fact there is no section 23D. Section 23D is on international will, created by a convention. The only thing that you need to remember at the moment is Hong Kong, even up to today, has not indicated a commencement date of this convention. So we have signed in to the convention on this international will, but the next step is the date of commencement. Even up to today, there is no commencement date announced whatsoever. The end result is section 23D is not part of the Hong Kong law now, yet. So, in other words, for our understanding on formal validity, the number 1 point in terms of formal validity is section 5 subsection 1. Then there are 2 exceptions. One is section 5 subsection 2. Second is section 6. That's it. All right? Now we move on to what we have just discussed. Now, in our actual practice, every time when we talk about formal validity, we always quote this. This is extract of the Court of Final Appeal judgment in Lincoln's case. This slide has stated all the necessary features on validity of will. Number 1, there is something called burden. Burden means responsibility. Who has the burden? Meaning, who has the responsibility? So if you have the responsibility, then it is your job to get 51 marks out of 100. If you fail, then the will fail. Because they say the burden is on the will propounder. Will propounder is any person who would like to apply to the court to convince the court that this particular will is a valid will. Any applicant like this is called a propounder. He may be a plaintiff, he may be a defendant. Normally it's a plaintiff, of course. But then, for example, if there is a plaintiff saying that, all right, this is the 2021 will that should be valid, and then by way of defense, the defendant said, no, I say 2021 will is not valid. It should be the 2019 will that is valid. So there are two will propounder. One is on the 2021 will. The other propounder is on the 2019 will. He who suggests that a particular will is valid is called a will propounder. Then he has the burden. He has the responsibility. The responsibility normally is what we call a balance of probabilities. Is a balance of probabilities, meaning 51 marks out of 100, civil standard. In order to prove, according to Court of Final Appeal, in order to prove that all three elements are being satisfied, so propounder has the responsibility to get 51 marks in respect of three items. Item 1 is due execution. Due execution here means formal validity, means section 5 subsection 1, meaning writing, testator signature, as well as what? What is the third element? On, say it again, louder. The third element, on validity of will, first writing, second testator signature, number 3, witness signage, which is called attestation. That's right. So that is item 1. That is item 1. Due execution. All three items, all the three elements has to be there normally if we are relying on section 5, subsection 1. But if we are relying to prove due execution on informal will, then if this is section 5, subsection 2 that we are relying on, that means we need only to prove the first element, which is document. In fact, when we say the first element, it is the only element which is document. Of course, now you remember then there is a difference in the standard of proof. The second item and the third item are together known as the substantial validity. Substantial validity. You can see here, according to Court of Final Appeal, it singles out, first is the testamentary capacity, and the second and the third one is what we call knowledge and approval of the testator on the will contents. So just one slide, we know all the essential features that need to be or that are required to be proved in order to get a will to be declared valid by the court. In a while, we shall go and examine the substantial validity to see what is substantial validity, see what kind of capacity are there. Then we should be able to understand them step by step. So just to conclude, in order to prove a validity of a will, we need due execution, which is formal validity, as well as the substantial validity, which is the capacity and knowledge and approval. That is what is stated by the Court of Final Appeal. Now, in order to understand the substantial validity, this in fact takes us back to the slide. I mentioned to the class very briefly, there is one or two words listed there, which is the substantial validity, which is the conclusion. This is one small b highlighted in yellow, intended. See that? Intended. It's about the fourth line down from top. And then the other equivalent terms is the fourth line from the bottom. The fourth line from the bottom is testamentary intentions. Testamentary intentions. So it is in these two words that we can see even the law, although very briefly mentioned, required the substantial validity to be proved. So all this intended as well as testamentary intention relate to the second and the third item in the slide just extracted from CFA, meaning testamentary capacity as well as the knowledge and approval. So this is how you link up the logic. In order to talk about substantial validity, we started with the first stage, which is legal capacity. Legal capacity is very much tied in with what we have mentioned before about minority interest, if you recall. Minority interest is where the beneficiary, some of them are underage. So we call minority interest. Then, legal capacity is the age of majority. So generally, one has to be 18 in order to have the legal capacity. Of course, under Section 4, you see the exception, if one can validly marry under 18, which is rather rare in Hong Kong. All right? So it's just enough to remember is 18. So you are an adult. So this is the legal capacity. The first hurdle. Exception, privilege will. If one is in a position qualified to make a privilege will, there is no age requirement. That's all you need to remember. So generally, first hurdle must be of age. Legal jargon, possess of the legal capacity. The second hurdle is called the testamentary capacity. This second hurdle can be very confusing. It can be confusing because we tend to confuse the word or the term testamentary capacity with another term called mental capacity. All right? There are fine line of differences, but let me show you by way of example, then you know the difference. On the one hand, you want to make a power of attorney. It's a legal document. A makes a power of attorney in favor of B. So by the power of attorney, B can operate and perform whatever act which requires to be done by A. So this is power of attorney. On the other hand, we have a will. a will. C makes a will. In the will, C gives whatever direction under the will for disposal of his property, which disposal will only commence to take effect when C died. The last part of the condition is very important, which tells the difference between power of attorney with will, namely the date to take effect. Now, if I make let's consider this evening, I make a power of attorney. Again this evening, I make a will. If you are asked to consider, are they valid? Are they valid? The moment I finish the execution of these two documents, are they valid documents duly executed by me, Mr. Wong? I am the A in the power of attorney. I'm also the C in the power of attorney, in the will. The question now I pose to you is, okay, now in front of you, I finished execution of these two documents. The question now I ask you is, well, okay, this is done. Is this a valid document that Mr. Wong just executed? The answer is very simple, either yes or no. Okay? If you pick the right choice, you pass. If you pick the wrong choice, you fail. The short answer is both documents are valid, assuming all the requirements are satisfied. The essential features of a will is that even though this will made by Mr. Wong this evening is valid from the moment I make the will, yet this will, this legal document, will not take effect until some time away. That is the date of my death. So it may be somewhere in future, which will come anytime, but we don't know when. This is the essential feature that you should remember. And this feature, in other words, whatever direction that I make under my will only take effect when I die. The legal jargon that you need to remember is, this is what we call testamentary. Okay? Testamentary. So we have this testamentary capacity. Now back to where we were. Well, Mr. Wong, when you sign these two documents this evening, do you have the mental capacity? Or Mr. Wong, do you have the testamentary capacity? So then by asking these two questions, you probably will tend to say, yes, Mr. Wong, well, you are of sound mind, you are a person with the right mind. Number one, you may be stupid, but you are still normal. Okay? So I think you got the capacity, Mr. Wong, this evening. So, medically, health-wise, Mr. Wong is accepted by you guys as a doctor to say that, Mr. Wong, this evening you have the right mental capacity, meaning you have got the mental capacity. You are not an idiot. You are not crazy. You are not out of your mind. All right? So this is mental capacity. The line to draw here, mental capacity is not the same thing as testamentary capacity. So this is the thing that I want you to remember. So testamentary capacity is something a little bit more than mental capacity. Even though I'm signing two things at the same time, two documents at the same time. One is the power of attorney, which is to take effect immediately. The other is the will, which is to take effect when I die. The capacity requirements are not the same. The fact that I am of mental capacity does not mean that I have the testamentary capacity. That is the thing that you must remember. Every one or other year, we ask will validity in examination. Sometimes on formal validity, sometimes on substantial validity. So you might as well remember them all. So here the starting line is mental capacity. I'm not crazy. I have the mental capacity. But for making a will, I must have something more. I must have the testamentary capacity. Then the test is, as set out here, you must prove that Mr. Wong is of sound mind. This is a legal jargon, although very in simple words. Sound mind. Sometimes called sound and disposing mind. They all come from judgments over 1 century ago. Okay, sound mind or sound and disposing mind. Then you must follow the judgment in Banks and Goodfellow, 1870, when the judge laid down three elements need to be proved in order to show that Mr. Wong has got the testamentary capacity. This is where the different lines between mental capacity and testamentary capacity. Mr. Wong, you're okay, you're not crazy. But in order to show that you have the testamentary capacity, you need to prove these three things. Number one, when you make the will, you need to understand the nature of the will. Which means, Mr. Wong, you need to understand this particular will not take effect until you die. This is the key element. And what is the effect? The effect is, although Mr. Wong, this evening you make the will, whatever you have indicated in the will, although this is already valid, since it does not take effect until you die, and until and before you die, you can always revoke them. So this evening you make a will, tomorrow you make another one, and day after tomorrow you make the third one, so on and so forth. All the wills are valid when you made it. All the wills are valid and generally will revoke all previous wills. So this is a feature of testamentary capacity and the Testamentary Act. So you know that you make a will. It's not, the legal term is called, it is not irrevocable. A will is a revocable act. Second, extent of the property. Mr. Wong, when you make the will, do you know what do you have at the moment? And what kind of property are you holding? Generally, in this question, we tend to understand it to mean, Mr. Wong, are you having only $1,000? That's all you have at the moment? Or are you having 10 million at the moment? So you know how much money, you know what kind of property you possess. Are you a beggar or are you a millionaire? So that tells a lot of difference when you know the extent of your property. So when you say, Mr. Wong, when you die, you give all your property to the community chest. When you do this, you were thinking that you only have $10 in your wallet. So give $10 to the community chest. They need to issue a receipt and a letter of thanks. Probably it's more than $10. You must be crazy, Mr. Wong. You think that you have 10 million. You give everything to the community chest. Or you think that you've got only $10, you give it to the community chest. So the consideration, the balance must be different, isn't it? If you are a multi-millionaire, you give everything to a charitable organization, there must be good reason. Well, whether your family members would require them, they are already very rich, so on and so forth. If you have old mother, old father, wife, and then young kids, they all rely on your giving, on your support. What kind of person are you, Mr. Wong? You have left behind all your family members and give everything to the charitable organization? Or in your will, you give everything to your girlfriend or your boyfriend? You must be crazy. They all say that, charity starts at home. You should start with your parents. You should start with your wife and your young kids. Then if there are some surplus, you give it for charity. That's reasonable. Even you have a girlfriend, you have to support your family first. This is the norm, what we call the norm. If you do not behave properly like this, people will tend to think, well, do you know what kind of property do you have? Now, I switch a little bit to the third one, but the other thing is, I don't need to give anything to my wife. For one simple reason, I've got a policy, insurance policy. I have indicated everything goes to my wife. Or all my property are being held in the joint name of myself and my wife. So when I die, the joint property will go to my wife as surviving joint tenant. So apart from that, I only have $5,000 in the bank. I don't mind giving it to charity. So I understand what I have. So I make a provision in a will that I understand my property. So that is the reason why they need you as a testator to have this testamentary capacity. You know the nature of the extent of your property. You know the nature of the property holding that you are acquiring at the moment. And the third item is what I've just briefly said about the claims, the likely claims to be beneficiary. So I repeat what I've said. I've got old parents. I've got a wife who is not working. I've got young kids who are only about 5 to 10 years old. These are persons that are likely to be beneficiary. They have a natural request for my support. You are the head of the family. Okay? You are the key breadwinner. So in your will, you are expected to do this. These three items is what is laid down in the Rule of Banks and Good Fellow in order to prove whether Mr. Wong has or has not got the right kind of capacity. And this capacity we call testamentary capacity. Got it? So whenever you are asked to talk about testamentary capacity, all this will have to be repeated. Burden of proof, propounda. Okay? Balance of probabilities, 51. 50, rely on presumption. So the third one, again, still on substantial validity. This is what we call, should be, the title, please correct the title here in this slide. The title should be corrected to read as Testamentary Intention. Cross out the words capacity, burden of proof, to change it to read as Testamentary Intentions. Intentions is the word that we said in section 5, subsection 2, the fourth line from the bottom. Testamentary intention. In knowledge and approval, although this is set as one legal jargon, in fact, these are two stages. Number one, knowledge. Number two, approval. Mr. Wong, you have got the legal capacity. Mr. Wong, you have got the testamentary capacity. But Mr. Wong, do you understand the will? Mr. Wong received only primary education, originated from mainland China, just come to Hong Kong 5 years ago, do not understand any English. So Mr. Wong signed a will which is in English. The first question that you will ask is, Mr. Wong, you signed your name in a document which you don't understand sufficiently. I wouldn't go so far to say that you don't understand anything, but some major parts, if it's in English, you don't understand. And if legal jargons are used, there is every reason to say that or to think that you don't understand the contents. This is particularly so if a will is in one language and then the signature is in another language. If the will is in English, then the signature is in Chinese. You may extend this to say if the will is in traditional Chinese, that's the word that we use now in Hong Kong, and then the signature is in simplified Chinese and with complicated legal jargons. So even though in Chinese you don't expect people to know all these niceties, somebody just, by looking at the simplified signature and then followed by the fact that he just arrived up from across the border very recently. So we can reasonably attack to say that he has got no knowledge of the contents of the will. So this is the first aspect to attack on knowledge and approval. The second element is approval. All right, the will is in Chinese, the signature is in Chinese. Well, how can you tell that Mr. Wong understand and then approve the will? He understands the contents. It doesn't mean that he will agree to the contents of the will. The contents of the will is for testamentary disposition. Testamentary to take effect only when Mr. Wong died. Disposition usually is a gift of the property. It's a gift of the property of Mr. Wong, which is to take effect when Mr. Wong died. So, how can you say Mr. Wong approve it? How can you say Mr. Wong agree? When you can prove Mr. Wong has been sick all the time. Mr. Wong is now aged person, meaning he is over, let's say, 80. Or you can prove that Mr. Wong is suffering from all kinds of mental old man disease. All this are modern examples to attack that Mr. Wong does not have the necessary approval. Okay? He understands Chinese, he writes Chinese well. He got a university degree. But then he is too old and too sick. Then we can say that he can hardly approve the will to give everything to the community chest. Don't give nothing to the family members. This knowledge and approval, we have a jargon which is called want of knowledge and approval. So want of knowledge and approval is a legal jargon to say that a person does not have the necessary testamentary intentions. Evidence of knowledge and approval. On the other hand, you need to prove Mr. Wong really knows the contents and he further agrees to the contents by judgment, by decisions. Okay, if you can prove that Mr. Wong is okay, he got the testamentary capacity, he got the knowledge and approval, when he gives the will instruction, meaning to prepare a will, to say what are the contents, who is to be what is to be given to whom. The other two things the court will usually accept is, well, before he signed, the solicitor read the will to the testator. The third element is the will read by the testator himself. So after Mr. Wong, Mr. Wong is a testator. Mr. Wong makes a will. He is the preparer. Okay, student A is the preparer. And then he and another witness come to my sick bed and he take my will and read the will before Mr. Wong. So this is the second item. The will is being read by the solicitor to the testator. Better still, after he has done this, he should give the will to Mr. Wong. Hey, Mr. Wong, why don't you read the will yourself? Okay? So this is just like an additional measure in order to show that he has given me some time to read the will, and I did spend some time reading the will, and after reading the will, the solicitor said, hey, Mr. Wong, is it okay? Do you agree? Then I nod my head, yeah. Okay, all right, you can sign. Then start the execution. So these are the elements. Usually, we also ask for one further evidence is the contents of the will. Sometimes we'll say the contents of the will is rational. R-A-T-I-O-N. If the will is rational, then with all these three elements, the court can easily come to the conclusion that on the balance of probabilities, Mr. Wong did have the testamentary intention when he signed the will. So, one way that we should remember is we should always encourage the testator to give something to someone even though that he does not like. For example, don't make it to the extreme. When Mr. Wong make a will, Mr. Wong said, I don't want to give nothing to my wife. Then you just follow my instruction, prepare the will, and then I'll say, Mr. Wong, in your will you said when you die you give everything to the dog. All right. The best way is the will is rational. I insist to give everything to my dog. Okay, then you say, Mr. Wong, you have given a lot of stuff to your wife already. Surviving joint tenant, he's got 20 million. And the wife have been away for the past 50 years, even though there is no formal divorce. All this repeated in the will. Why do you give everything to your dog? Oh, because my wife ran away for the last 50 years, and then my dog has been with me for the past 49 years. He joined me the year right after my wife disappeared, and then he has been with me for the last 49 years. For a dog, 49 years, you have to multiply by 7. I've got such a faithful dog, which is better than my wife, who has disappeared. And now he is sick, okay? There is good reason that I should provide him adequately, or not him or her or it. Therefore, I will give what I have, is about 2 million. That should be sufficient to look after my old and sick dog. Give all the reason in order to say why you have decided to do what you said in the will. Then this will explain what we call the rationality. Now, at the moment, the law in Hong Kong is this. We still respect this testamentary freedom. The argument runs on 2 steps. Number one can dispose of his property in any manner that he likes. This is a capitalistic society. You earn your living, you earn your saving. This is number one. This is all yours. All yours. Number 2, well, you can give something to your other family members or not. Nobody can say whether this is yes or no, right or not right. Following this testamentary freedom, you can give it away in your lifetime, isn't it? I got $1 million. I've been teaching in Hong Kong U Space for the past 10 years. This is all my savings. But since you students are so good, I'm so impressed. Every time you come here and you eat and you sleep, okay, all before me. You guys have been very good and you pay. So I say, oh, I'm so impressed. Now, I take out my wallet, okay, $1,000 to you, $10,000 to her, and then this is my inter-Bible gift. There is no law in Hong Kong that prohibits it. I'm always entitled to give whatever gift to whom that I like. You guys are my best students. I want to give you more money so that you all will become lawyers in future. You can eat better, you can sleep better, and you can get your solicitor faster. This is valid inter-Bible gift. Now, if this is valid inter-Bible gift, why is that the law should treat it differently? If I make a will, I don't give it to you now, but I say in my will, all my students, each of you will get $1 million. What is the difference between a inter-Bible gift to a testamentary gift? There should be no difference. So this is the argument. So we have to show that, oh, I'm impressed by you guys. I know the extent of my property, and then I think I should give it to you. So this is how to prove approval. Remember, knowledge and approval must be proof. There's no presumption. You need to give express evidence to show that I am having the knowledge. I approve the will. before I come here, the other thing I also like to add to knowledge and approval is this. Apart from what I have discussed on testamentary capacity and testamentary intention, there is a further element which may affect the approval. This is what we call fraud, F-R-A-U-D, duress, D-U-R-E-S-S, misrepresentation, M-I-S-R-E-P-R-E-S-E-N-T-A-T-I-O-N, representation. Now, all these three examples are on top of what we have just discussed on approval. Because these are third-party act over my own thinking. I am unable to freely agree. You are pointing a knife. Mr. Wong, sign it, you can live until tomorrow. You don't sign it, you now go to heaven. Or, Mr. Wong, why don't you sign it? You know, this is something, this is a contract, sign it. This is power of attorney. Without telling me that this is in fact my will, giving everything to whoever. Misrepresentation. Fraud. In Lina Kong's will against her father-in-law, against the will of Wong Te Kwai, they say, no, this is not the right signature. This is a forgery. This is fraud that we talk about. All these are rationale to counter the argument of knowledge. All right? This is the judgment of the Court of Appeal that has aroused a lot of discussion amongst the legal practitioners in Hong Kong. The Court of Appeal, Judges Jiang and Guan, then they say, in Hong Kong, this arises from the case of Owen Lun's case. The probate lawyer I just briefly mentioned. The court ruled against him. The Court of Appeal also ruled against him. What he did was, he is a probate lawyer. He asked another solicitor to prepare a will. And that other solicitor got the instruction from lawyer Ao, prepare the will. The will itself, the contents is okay. One half to my brother, one half to myself. Appears to be normal. But then the other lawyer don't know the previous will and don't have the chance to take instruction from the testator who is living in an aged home. So he prepared the will on instruction of one beneficiary, a probate lawyer, lawyer Ao, and then having prepared the will, go to the aged home with his trainee solicitor, spend no more than 15 minutes. Oh, I have read over the will to you, old man, and then the old man signed. That is the will trying to be proved. And then the Court of First Instance and the Court of Appeal find this very unsatisfactory. Not only that, Solicitor Ao is one of the most experienced probate lawyers. of the fact that how can other solicitor take instruction from somebody else without knowing the testator, never knew the testator before, and then this testator is old, in aged home, spend only 15 minutes, no more. What you have done, can you prove to this court that the testator has the right knowledge and approval? This can hardly be the case. It's most unsatisfactory. The Court of Appeal was most upset at the moment, at that moment. That's why in this judgment, when I said at that moment means at the moment when the Court of Appeal judgment was given. The Court of Appeal judge was very annoyed. So they say, all right, in Hong Kong, instruction to prepare a will often given by adult children of testator. Testator is elderly and in ill health. Then, solicitor who wish to discharge the duty should meet the testator personally for the purpose of taking instruction or confirming the instruction. So now you have an option. You receive initial instruction by telephone from the beneficiary, one of family members. Okay, we accept this. But then you need to seek confirmation of instruction personally. How you can do it, it depends on the circumstances. But then there is a need for you to seek confirmation. If not taking instruction personally, don't ever take instruction from somebody, some third party, particularly when it's related to a beneficiary or major beneficiary. So this is what we call a suspicious circumstances. That suspicious circumstances only will result in the will being held invalid. But here in this Court of Appeal judgment, the Court of Appeal is in fact criticizing not the beneficiary, but the lawyers. This is why it's so controversial. They say, okay, you have to take instruction personally or seek confirmation of instruction personally. When it says take instruction or confirmation personally, it means the court expects not only just from you guys as experienced legal clerk. That is not enough. Solicitor will have to do it themselves. This is in person. All right? So, he should do this well before the day appointed for the execution, meaning you cannot do it in the same day. So in other words, to make a will, number one, you have to take instruction. Number two, take confirmation and instruction. Number three, execution of the will. So at least 3 separate occasions for a will which you charge only $2,000. So that becomes a public service, isn't it? How can you make a living for a lawyer? It cannot even support the charges of, those of us sitting here in this class. 3 separate occasions. You must be joking. Are you saying that we should charge a will for $100,000 per will? You either kill the testator or you kill yourself. Isn't it? Then, the other thing that follows, the Court of Appeal judge referred to something from England, the British checklist, and the British Golden Rule. These are 2 separate things relied heavily by the Court of Appeal. One is the British checklist. The other is the British Golden Rule. In order to show that what should be done by a solicitor charged for the preparation of a will, what should we do? This is the Golden Rule. The British Golden Rule is 1975, Cameron Adams. That's what it says. When a solicitor draws up a will for an aged and serious ill testator, he should be witnessed and approved by medical practitioner or to record his examination of testator and his findings, that an earlier will should be examined and any proposed alteration should be discussed with the testator. Now, this rule is controversial. The reason why this rule is controversial because this is not a judgment. This is something, is made in passing. It is part of a judgment, but not formally, in a sense. This judgment is only reported in the newspaper and is said by the judge in wordings which is less than formal. All right? When I say less than formal is there is something which can be arguably said that they are inconsistent and they are contradicting with each other. Look at the wordings. When a solicitor draws up a will, what do you mean by draws up a will? Are you saying that solicitor preparing the will or attesting execution of the will? What do you mean by draws up a will? If you mean what you said, when I draw up the will, all right, it should be witnessed or approved by a medical practitioner. So when I prepare the will, then I should be witnessed. What are you talking about? I draw up the will is not yet executed. How can it be witnessed and approved by a doctor? We don't get to that stage yet. We are in the preparatory stage. So in order to make sense out of it, the court must be saying that, okay, solicitor draws up will for agent, then when execute the will, then there should be a doctor, isn't it? A doctor to examine the testator. Oh yeah, he's sound mind, okay, he can sign it. What a doctor can do is nothing more than a mental capacity, not testamentary capacity. Unless you're asking the doctor to do the 3 tests that we have just discussed. Hey, Mr. Wong. Hey, how are you? You know what you're doing? You know the extent of your property? How much money do you have in your purse? Cash in bank? Tell me how many kids you have? How many father and mothers you have? What are the cats and dogs that you need to support? Unless you're asking the doctor to get all these tests on testamentary capacity test, that must be something more than expected from a doctor. A doctor can only say, oh, I have examined Mr. Wong. Mr. Wong is not crazy. I did a test. The test this is what we call the MMSE test. Maximum score is 30. Okay, this is what they're doing at the moment. 30 maximum mark, and then he scored 20. Below 20, 21 is fail. Above 20, then is pass. Above 20 or more, then he has the sound mind, the medical capacity, then he can make a will. That's all we can expect a doctor to do. That's on medical capacity. That's on mental capacity. And then the solicitor will need to ask, oh, have you made any will before, Mr. Wong? It's not that. That is not the only question. We'll go to the third aspect in a while. Any proposed alteration? Well, last you make a will, you give everything to the cat. Now in this new will, you said you give everything to the dog. You know the difference between the cat and the dog? Oh, yeah, they all have 4 limbs, you know. One runs before, one runs faster, whatever. Now, all this are less than perfect. Cameron Adams are no more than a warning by the court to say that, well, we need to be very serious when a will is executed. We have to be careful to make sure that the testator knows what he's doing. Okay? So this is only the golden rule. It's not part of the judgment. Then, we have what we call the British checklist. British checklist comes after the golden rule. Golden rule is 1975. The British checklist on testamentary capacity It's published about 20 years later. Now, since then, it has several modern editions. But it is something that serves to expand on what we just discussed on the 3 items in Banks and Goodfellow. If you have the time to look at the PowerPoint before you come to class, you probably will now appreciate Banks and Goodfellow, nature of act and effect, extent of property, and the family member likely to have a claim. These are the 3 items under Banks and Goodfellow. Then in the 90s, British checklist on testamentary capacity, they expanded on it. So we know, what are we talking about? Nature of the act? Understand, you know that you will die, huh? Of course I know I will die. You know the will take place when you die. All right, okay. And you can always change it before you die. So all these are common sense that is put in a way that should be understood. Effect of the will. Now this second item on Banks and Goodfellow, isn't it? Then give you more example. Well, who should be the executor? Why do you choose Mr. A as the executor? You should have chosen Mr. B. Isn't that your son? So all these are things. Who will get what? Outright or conditional? And then all this. These are the various items suggested by the British Law Society and the Medical Association to say, these the items which is expanded on the Banks and Goodfellow that we prepare the will should be able to single out the questions to be raised. Nature of act. Third, extent of property. Well, do you know how much you have? Do you know how many of them are in joint tenancy, etc. So these are for you to understand. And claims of others. You got so many kids. You don't give them evenly. Some deserve more. Some are better to you, some are poorer, so on and so forth. All these are but just examples in the British checklist to assist the solicitor preparing the will in order to ask more pertinent questions following the test of Banks and Goodfellow. This is what they are. Then, in the same case, the court will say, now, this is court of appeal, they say, when you make a will, as a lawyer, these are the items that you should ask. This is like the 10 Commandments. Age, health. Do you have a surviving spouse? Number of kids? And remote issue? Any dependents? Any girlfriend and a boyfriend? And beneficiary like to provide in the will. You love your son, give him more. You love your daughters, give them more. Properties, extent of your property. Have you made any old will? Do you know that the old will revoke the new will revoke the old will now? This happens very frequently these days in Hong Kong. Clients will come to you to say, I want to make a new will. Sometimes it's new will to revoke the old will. Sometimes they will say, I want to make some new wills, but I don't want to replace or amend the old wills. This comes by way of the fact that people these days in Hong Kong, they tend to have lots of assets in different jurisdictions. You make a will that deals with all your property in Hong Kong. Then I may have 2 houses in Dongguan. Okay, I want to make another will in Hong Kong concerning my properties in Dongguan. And I expand it a little bit further. Like, I have property in Vancouver. I have property in Sydney. It's very frequent nowadays, apart from tax reasons, they would make new wills here and there. So we need to tell them, you know that, how much will have you made before, Mr. Wong? You know the difference between the old and the new? Okay. Then all these are things that we are required to ask, to find out. So all these several slides, from here, okay, 2020, all this arises in the same judgment up to here, all from the same Court of Appeal judgment. And that has stirred a lot of controversy in Hong Kong. So therefore, in the past year, in 2020 and then in 2021, there are then two other Court of Appeal judgments. They realize that they have using the words too strong. You don't expect a solicitor who can do this, within such a tight budget. Particularly in Hong Kong, when you know that people can make the will themselves. So you're asking for the impossible. So therefore, in the third Court of Appeal judgments, a different judges in the Court of Appeal, they make, the modern trend. The modern trend is not all this. The modern trend now, apart from, all these are good things, we need to study them. But then the emphasis now today is what we call the holistic approach. Meaning, you look at all the happenings of a testator in the past in order to decide whether there is substantial validity, whether there is any knowledge and approval. All right? Okay, let's take a break now.